Thanks for the wonderful introduction, Chris. I'd like to reiterate, if you guys have any questions, please ask. It makes it a little more interactive, and quite frankly, I'm going to help you, give you guys information that's beneficial and will benefit to you. I'm going to go over basic estate planning documents in Indiana, what they are. I've had somebody call me, ask me about Michigan. We also practice in Michigan. Michigan's documents are a little bit different. So if you have Michigan-specific questions, we can talk about those after. We can set you up with one of the Michigan folks. But I've got a general knowledge of what the differences are for those documents as well, for anybody who's interested in Michigan or over the state line. The first basic general document that everybody knows about is a will. Right? Everybody needs a will. Why do I need a will? You know, some people say, "Oh, wills are bad. They go to probate." I don't like to think about wills. If you have a general estate plan, a simple estate plan, a will allows you to decide who gets your assets when you pass away. If you don't have a will, the default is decided by the state of Indiana. A lot of people do not like, or Michigan. A lot of people do not like what the states decide. You know, maybe it's going to be split between your mother-in-law and your children and your spouse. Maybe your spouse isn't going to appreciate that your mother-in-law gets a share of your estate. So the will is the basic document that allows you to have complete say over who gets what. That goes for personal property as well. Post-it notes on the back of things, while helpful maybe to the heirs when they're going through the house, are not legally binding. And I have seen it. I've seen houses full, literally full, of colored sticky notes. You know, you can go through and the paintings, the furniture. You know, purple is for Johnny, blue is for Sarah. Not a great idea. If you want to have, if you want to divvy that stuff up. We can create addendums, we can create lists, and we can make sure that everyone gets the personal property that you desire for them to have. Wills are also, if anybody's got minor children in here or has children who have minor children, wills are also important because in a will you can put guardianship provisions to say who gets those children if you pass away. You know, maybe you want it to go to your parents, maybe you want it to go to a sibling, maybe you want it to go to a friend. But by putting it in the will, we're going to give priority to the people you want and forego any sort of complications or disputes over, you know, maybe you've got two siblings and they both think that they're better suited. Powers of attorney are the second type of document that everyone should have. There's two types of powers of attorney, healthcare and financial. We'll talk about the financial first. Let's say that you're in a coma, or you're in an Alzheimer's ward, or you are for some other reason incapacitated and cannot make your decisions, your financial decisions. We want to make sure that there's someone who can take care of your property and manage your assets for you. Someone that you trust, someone that is not just the first person who runs the court. And we want to make sure that there's, once again, not a dispute. You know, if you have two children and your spouse is deceased, they have equal priority. You know, I've seen a lot of cases where they both think that they are best suited to take care of mom or dad's estate. If you are going, like I said, in the first situation, let's say you were in an accident, you're in a coma or something else that you are going to recover from, your power of attorney needs to be somebody that you trust, but we also want them to make sure that when you wake up, when you go back home, everything is as it should be. You know, AEP, NIPSCO, they've been paid, you know, your house is still there, no foreclosure, everything is all neat and tidy. The second situation I mentioned, if you have, you know, Alzheimer's or some other debilitating illness and you're not going to go home and you're not competent to take care of your stuff, you want to make sure it's someone you trust, you can manage your assets and make sure that the care you need is there when you need it and can help, you know, navigate the system. Healthcare power of attorney is the second type. A healthcare power of attorney is a document that says who makes your healthcare decisions in the event you cannot make them. So let's say that you're in that car accident and you're unconscious, and the doctor comes out and he says, I've got 2 procedures I can do. Procedure A, I've done for 20 years, know it like the back of my hand. You lose a leg, 30% chance of survival. But there's this brand new procedure the FDA just came out with. It's option B. I've never done it, but it sounds like fun. If you make it, you don't lose your leg, right? You get to walk again. That's what they say. Who makes the decision? Who says, you know, procedure A, procedure B? This is the person that makes those calls. So it's, once again, a very, very important person, somebody you're close to, somebody who knows what you're going to want. Not only about, you know, those extreme situations like the car accident, but also, you know, end-of-life decisions. The next document we'll talk about is a living will, and in Indiana we have those, and those will give instructions to your healthcare power of attorney. Living will says if your death is imminent, heroic life-saving measures of nothing but prolong the dying process. You do wish to receive artificially supplied nutrition and hydration. You do not wish to receive it, or you intentionally live up to your healthcare power of attorney. And while that document is helpful and can give instruction, there's a long range of things in between, you know, simple car accident you're going to wake up from and hospice. And a lot of decisions in between that could be made. And so, you know, we really want someone who, even if they don't have any medical background, is someone you know is going to consult with the doctors and make the decision that you would want. Indiana, though Michigan has all of those things as well. Indiana has an additional document called a funeral planning declaration. There was a situation in Indiana where an individual had 2 daughters. His wife had predeceased him. He then passed away. His one daughter said, Dad told me he wanted to be buried next to Mom. His other daughter said, Dad told me he wanted to be cremated and have his ashes spread at the lake. And they were absolutely certain that Dad had told them each of these things. And maybe he did, I don't know. But they have equal priority under the statute as far as who gets the call, what happens with Dad. And neither one of them was going to give ground. So they went to war. They went to court to find out what's going to happen with Dad. So Indiana took a step back and said, is there anything we can do to help figure this out? Because your powers of attorney terminated your dad. The healthcare power of attorney, the general financial power, they're both done when you pass away. So we now have this funeral planning declaration that says, it allows you to list out, I want to be buried, I want to be cremated, I want to be entombed. I leave it up to someone. And we list out the person who is in charge in this situation. We'll pick one daughter. You know, it also says if you want to be, you know, where you want your funeral services from, where you want your church services from, where, I mean, all this stuff you can list out. Or like I said, you can just say, no, my oldest child figure it out, I nominate them, go. Yes, ma'am.
Now, why would you recommend like coming to you for that rather than going to just the funeral home and planning it with the funeral home?
You can go to the funeral home and plan. That's a great idea. And Wendell will talk about some of the, you know, Medicare, Medicaid planning stuff, and that's a good way to get some stuff out of your estate. And if you know what you want, if you know the funeral home you want, if you know the burial plot you want, if you have all that stuff worked out, I strongly encourage you to do that. It's a great idea. If you don't know, or if you forget something, or you miss something, it is good to have someone named or nominated to step in and fill the gap. But no, I definitely encourage you to, if you know, go for it. Any other questions? All right. Trust. The last wonderful thing I have questions about. There's a gambit of trust. There are many different reasons why people would want trust. Some folks say to avoid probate, right? I've heard a lot, probate is bad. I don't know if that's necessarily true. I think it's a situation by situation thing. But if you want your estate to be private and you do want to avoid the probate process, a trust is a wonderful tool that allows you to do that. Trusts are also good if you have minor children or minor grandchildren who you want to provide something for, but you don't want to, say, give a lump sum of cash to an 18-year-old. You want to give it to them over time, maybe 30, 35, 40. I have folks who do 60 and 65 and say it's for retirement for my child. The kids don't think it's funny. So that's an option, it's a benefit. It's your money, they're your assets, and you can lock them up like that if that's what you want. Spendthrift children are another reason. I mentioned 60 and 65 and people laugh, but there are a lot of folks who think that their children are not financially responsible, and they come and they say, "What's an option? How can I help them? Get through life, get to retirement." And once again, the trust is a good option for that. Special needs trust, if anyone has a special needs child, grandchild, niece, nephew, that's another situation where you set up a trust, you fund it, use that to supplement the benefits that would be given by the government or an aid agency or some other institution to the child. Once again, there are a lot of reasons for trust. And if you're interested in these, we can talk about them, we can answer questions. I'm more than happy to go into the who's and what's and where's and why's. And like I said, they're individually designed for individual circumstances because everyone is different. In our context, we can hit up and we do some stuff with the university where people ask, is there any way I can help out the university and my kids? And the answer to that is yes, of course. Trusts are a wonderful mechanism for this, and we work with the university to provide plans where you can do things like that. Charitable deed trusts are a wonderful option right now to do something like that because the interest rates are so low, and the University of Notre Dame's investment office is so good at what they do. Charitable deed trusts allow you to, say, give the University of Notre Dame $1 million. The University of Notre Dame invests the $1 million. The University of Notre Dame, you set it up, they get, say, $50,000 a year for 20 years. So the university is getting money every year. They're happy. At the end of the 20 years, the university will pay out to your beneficiary, whomever you decide, the lump sum that's left over. Let's just say that you get a 6% return on that. The current IRS Treasury rates are much lower than that 6%. So the difference is going to, the IRS is going to say, you pay $120,000 in taxes on that, and you get $1.2 million to give to your heirs. So what have we done? We've given the university money, we've given our heirs money, and we've decreased our tax liability. So like I said, there are many different things, there are many different situations. Everyone's unique, but that's a broad overview of estate planning documents. Wills, general power of attorney, financial power of attorney, healthcare directive, funeral planning declaration, and trust. And some of the things that we can do, or some of the situations we can plan for using those. Does anyone have any questions? Yes?
Generally, how much are we talking to drop a will, not only for your organization, but just in general, any organization?
Sure. I don't know generally, right? I mean, I watch those commercials for LegalZoom.com and they get you really excited because generally people go on LegalZoom, they print out a will and then they pass away, and that is a lot more work for me, so it's fantastic. But I'll tell you what we charge generally for the will, the power of attorneys, the funeral planning documents, It's $500. That's generally what we charge. The trusts are more, and if you're complicated, even with the basic documents, it can vary. But that's a general range for it. I don't know what the fees are in the area, but that's what we do. Yes?
Can you give a comparison for the trust then? Can you?
You know, we can talk after, but it really depends on what kind of trust you want. I mean, if you're talking about like you know, just something for a spendthrift trust for a child, I mean, it's so different than if we're talking about some sort of charitable trust, you know, for the university. And quite frankly, the complexity is so different. It just depends. So we'd have to talk about your situation, and then you can just kind of do what you want. I'll give you a range. But it just depends.
So what's on the low end, like a simple trust, just less, no complexity, just 2 children?
Maybe $600-700. Yes.
How general can you be with regard to the trust? In other words, what is the maximum life of the trust? Is there a maximum life? Can you be very vague in terms of who gets the money in the trust, but rather who needs it for a specific purpose for an indefinite period of time?
A trust will fail if it does not have a defined beneficiary. So you must define, if not a beneficiary, a class of beneficiaries. For instance, you could say my children, or my grandchildren, or my nieces, or my nephews, or the university. Define it. But you need to have some sort of either class of individual or actual named individuals.
Okay.
Now, as far as who gets the money, you could have a class of individuals, let's say my children.
Right.
And let's say those children who attend the University of Notre Dame shall have their tuition paid out of the trust. Totally okay. If there's money left over, when my youngest child attains the age of 40, it distributes out to all of them equally. So you can, like I said, once again, they're very flexible. There's a lot of things we can do. So if you want to set up a class like that, sure, of course, no problem. But you must have some sort of defined beneficiary. You can't, you can't just say the money's going to be used for, you know, people to.
Yeah. And then in the meantime, would the trust pay the income taxes on the earnings of those assets?
Right. You said that if you're going to have a trust like that, the trust gets set up. It's like its own person. Right. So you fund it. It's got its own tax number. It's got its own. Yeah. Now, while you're alive, I'm sorry.
I'm kind of what he's. I work with people with trust at times, and the biggest misconception that when they come, they have these papers and whatnot. And then you tell them, this money does not belong per se to you anymore. It belongs to the trust. You are in control of the trust, but the money now belongs to the trust. And they're, oh, no, this is my money. You put the money into the trust, the money belongs to the trust. Now, in the words of the trust, it does whatever it says to do in that documentation. But that money is no longer yours. And so it pays its own taxes, it takes care of itself. And a lot of people don't get that.
Now, if you're alive and you set up a revocable living trust, which means you fund the trust, you're the trustee, you make the decisions with the trust, you put provisions in that say you can also take the money out. And you can use the money for what you think is important. So in that situation, while the money still is the trust, it's not technically yours, you are in control of it. So there are ways, you know, some people think once you put money in a trust, you know, you don't have any power or control. That can be true. There are lots of irrevocable trusts. The charitable trust at the university, special needs trusts. I mean, there are a wide range of trusts that do work like that. But there are also trusts if you just want to do planning for your children, or you want to do, you know, set something up as a what if. You want to avoid probate. You want to keep your estate private. You can put it in a revocable trust. The revocable trust can give you the power, if your circumstances change and you deem it necessary, to remove the property from the trust. You can do that. Once you die, that trust will become irrevocable, During your lifetime, sorry, back to that tax point, during your lifetime, you can use your social security number for the trust tax. So you can, it gets all included because you've got control over the assets. Once you die, it becomes irrevocable. If it's going to last for a long period of time, then it will get its own tax number and live on as its own entity. Yes?
Does a TOD document, a transfer on death document, accomplish avoiding probate as well as a trust?
Yes, transfer on death documents do avoid probate, and we've got a bunch of wonderful things in Indiana that allow us to transfer on death. Michigan's a little more restricted in this area, but in Indiana, not only can we do bank accounts or life insurance policies or retirement accounts, which pretty much everyone can because those are contracts. You go into the bank, for instance, and you say, when I pass away, you know, I want my daughter Sue to be the POD, pay on death beneficiary, and then when you pass away, the money goes to Sue, no problem. In Indiana, we can do that not only with, like I said, those usual assets that most states can, we can also do it with real estate. You do a transfer on death deed for your house, so that when you pass away, let's say you've got 2 kids, you want it to go equally, it's the only big probate asset in your estate. You can do a transfer on death deed that says, I deed my house upon my death to my 2 kids. That asset upon your death is out of your estate. If your estate is under $50,000 for probate purposes in Indiana, meaning all of your retirement accounts have beneficiaries, your life insurance has beneficiaries, your bank account has beneficiaries, you did TOD for your house, we value your personal property at less than $50,000, you don't have any probate. You're good to go. Your kids will get an affidavit and a death certificate. They'll come see us. We'll have them sign. We'll record it. They own the house. You can also do it with cars, boats, RVs in the state of Indiana. So Indiana is very good about that. So there are things we can do to help you avoid probate if that's your goal, without actually doing a trust. If your assets would otherwise be over that $50,000 threshold. Yes.
Marcel, you might mention that, I don't know if it was a year or 2, Indiana did away with that inheritance tax.
But yeah,
That was a big deal.
There's no inheritance tax in Indiana.
Yeah.
That's probably why I didn't listen on your thing. So Indiana now is a good state to die in. Michigan does not have an inheritance tax either. However, Michigan charges a fee based on the value of assets in your estate. So potato, I don't know. But yeah, Indiana has no inheritance. Federal tax, I got I need a little handout of the words. It's currently $5.34 million. That is per person. So if you're married, you and your spouse each have that amount. There's currently portability, which means if you pass away, your spouse can file an estate tax return for you, and you can get their unused exemption amount, meaning that you now don't have $5 million, you now have $10 million.
Yeah, my question is more abstract, I guess, and that is, suppose after a person has passed, they have a will, okay, but their circumstances change, nothing is contentious, there are no heirs fighting back and forth, and it's clear where things are going. Is there a duty under Indiana law in particular to have to probate a will?
If the assets are over $50,000, yes, you're supposed to.
Now you just kind of watered that one down. You're supposed to. The
Yes.
law says you should be.
Right. If it's over $50,000 is the limit in Indiana. So if you're over 50, yes. If you're under 50, so if your probate assets are over 50, yes. If they're under 50, you don't have to.
Okay.
So that's Indiana draws that line at 50,000.
What is it? I'm sorry, what was the question? I heard your answer. But
He said if there was so let's say you have more than $50,000 in assets and you have a will, you have 2 kids, they get along beautifully, they're happy to divide everything up, there's no fighting, everything's great, but you didn't do any of the transfer on death documents, you just have the will, do you still need to probate it? If you're over $50,000 in probate assets, yes.
And how much are probate fees typically?
The probate fee is just a filing fee with the court. So it's whatever the current filing fee
So
is. There's no, there,
It's a set amount.
right, once again, there's no inheritance tax in Indiana. They don't, the court doesn't take a percentage of the estate or anything like that. It's just a set filing fee. It's a couple $100 generally. Yes, sir.
When I heard you mention a tax number for the trust, it made me think the maintenance fees, which will be very dependent on the complexity of the trust. But is there anything you can say about a very simple trust and an annual maintenance fee?
Sure. So, most trust companies, banks, asset managers charge they charge a percentage of the trust estate, whatever you've got in trust, as their fee. You get the fee schedules of the following fee schedules from any of the banks or trust companies you're interested in. If you have a son or a daughter or a niece or a nephew who is a financial advisor or is a financial genius, you can name them. And maybe you talk to them beforehand and they agree that they're not going to charge anything. Especially if it's one of your children. If your daughter's a financial whiz and her brother's not, but they get along beautifully. She says, yeah, I'll take care of it for 10 or 20 years until we distribute it out to our kids, your grandkids, dad, no problem. So in that case, if you've got a relative who's doing it, they might not charge anything. If you use a bank or trust company, like I said, they've got a fee schedule, you can get it from them. As far as the accountants go, for filing tax returns and stuff, once again, there's a wide variety of fees, whatever that they charge. In my experience, if it's someone that your family has a relationship with, tend to be less. They're doing not only the trust taxes, but they're also doing family's taxes. Then if you just hire a trust company and they do it as part of what they generally do. But once again, that depends on your own individual situation. There are folks who do not have that child who is the financial whiz, and they set this up because they want to make sure that their children don't blow money. Yes.
In the case of real estate, does the transfer on death document need to be recorded?
Yes. You record the transfer on death. But you can revoke it any time. So it's not a permanent thing. Sorry, my apologies, I didn't clarify that. So we record the transfer on death deed, but until you pass away, you can revoke it. You then file a simple document that says, I revoke. So let's say, you've got 2 kids, a son and a daughter, they're both great, everything's good, you do a transfer on death deed, your son all of a sudden thinks great, he's got the lake house, he no longer comes around, no longer says hi, revoke it, change it, just put it to document, good to go.
Now, if the real estate is in the name of joint tenancy with right of survivorship, that document would not take effect until the death of the second party, right?
Yeah. And those get a little more complicated. What we generally do then is we write it so that the surviving spouse could revoke it, right? You don't want to lock your wife into having, once again, let's say everything's great, you pass away, your son never comes around anymore, he doesn't care about mom, your daughter's doing everything, she's there, day and night, grieving, whatever, you can change it. Yes.
We had a will made up 20 years ago. Our financial advisor pointed out to us that it doesn't cover what could happen. Say we're both in a car crash and one dies at a different time than the other. He recommends we get a new will to cover that. Can you comment on that?
Sure. What you're talking about are simultaneous death provisions. They should be standard provisions in estate planning documents. Some people say you must survive by 30 days, some people say 90 days. Ours typically say, if you can't tell who outlived the other, we're going to presume that the wife survived the husband, right? Why? People ask me, why the husband? Well, not only because statistically speaking the husband goes first, but because she's going to heaven and the husband needs to make sure it's ready when she gets there. So that's why I write that in. If everything else in your will is okay, it's fine, you're happy with it, it's 20 years old, but that just means it's collected some dust, not that it's not otherwise all right. You can do a codicil to it, add a simultaneous death provision, and you're all right.
Can I ask a follow-up question?
Sure.
we named executors, and a fine article this summer I read in the AARP bulletin saying, well, pay them something like $2,500 for being executor, and have that somehow built in. Can you comment on that?
Sure. Personal preference. If you've got a close-knit family situation, then I don't typically recommend, but I don't know how many kids you have. Once again, let's say you got two. It makes my life easy, right? You know, son, daughter, everything's great. Like, you know, you choose your son to be the executor, right? But he's kind of doing it, quite frankly, as a service to mom and dad and his sister. Does he need to be paid? No. Do you have to pay him? No. If you want to pay him, sure, we can put a provision in that says they get paid. We don't usually set an amount, say $2,500. What we usually do is whatever's reasonable. They keep track of the time, file it with the court. Judge says, I'm going to give you $10 an hour. Let's say it's crazy, it's awful, it's for, you know, your financials, papers, and documents were an absolute mess. I mean, you told time with his son died. Your son goes in there and says, oh my gosh, what do my parents do? And he spends literally days sorting this stuff out. Maybe the judge says, you know, it took a financial whiz, we're going to pay him $25 an hour. So it depends on the circumstances. So that's what we do, but we for approval in all those situations, it goes before the judge. You know, your daughter, his sister might go in and say, yes, he deserves every penny. So it all depends. Yes?
You touched on this earlier, but what are the advantages and disadvantages of having a revocable trust to put your assets in while you're living versus going through probate?
Okay. Privacy is the biggest one. If your family members are not going to contest your trust, then it does not necessarily have to be docketed. So when you pass away, the trustee will, you get a new trustee, right? The trust becomes irrevocable, the successor trustee takes over, they manage the trust. Let's say it says distribute everything out immediately. They collect the assets, they distribute it out immediately. In Indiana, if you've got a probate estate, there is a 3-month waiting period to give notice to creditors. Forgo the 3-month waiting period, although I will tell you, if I'm the attorney for your successor trustee, I do like to wait a little while to make sure that, you know, a hospital bill doesn't pop up, or you know, your credit card bill, or whatever it is. Because then they could then open an estate, reclaim the assets from the beneficiaries. In my experience, at least one of those beneficiaries has already spent whatever it is they were getting, and then things get a little messy. So privacy is the biggest thing. Faster timetable is the second. Let's say you've got unknown creditors, or we don't give notice, or we wait to open up an estate. A creditor has 9 months to open up an estate before they're barred in Indiana. So if you do a trust, once again, we can move things along a little faster. The other issue with privacy is if you want to give different amounts to different people. Once again, if you don't think anybody's going to be contesting it, you know, maybe your son doesn't know that your daughter got $200,000 more. That might be good for family unity going forward. So that's about it. All right, well, thank you. I will be around after, so if you have any questions that you want to share with the group, feel free to seek me out.